As we gather here today, I am reminded of the words of Justice Antonin Scalia, who said, "Drafting and pleading are the twin pillars of effective democracy upon which the entire edifice of justice rests." Good morning, everyone. Respected Dean, Professor Dr. T.R. Subramania, Director Vijay Praneshwaran, all the faculty members of CMR University School of Legal Studies, and the students. I, Maria, a fifth-year student of BBA LLB, on behalf of CMR University School of Legal Studies, welcome you all to an engaging session on the techniques of drafting and pleading. To begin, I invite Dharani, a third-year student of LLB, to render the invocation song.
Hamsavahini Jnanadayini Hamsavahini Jnanadayini Jnana ka bandar de Sharade vardhan de Jnana ka bandar de Sharade vardhan de Hamsavahini Jnanadayini Jyotidatri O Vidatri Jyotidatri O Vidatri Jyoti ka sansar de Sharade vardhan de Hamsavahini Jnanadayini चल सके निज सत्य पथ पर गा सके निज गीत हित कतीपों को हार दे शारदे वरदान दे हमसवाहिनी ज्ञानदायिनी हमसवाहिनी Jnanadayini Jnanadayini.
Thank you, Dharani. We are honored to have amongst us today Ms. Susheela Sarathi, a familiar face, returned to our stage to share new insights and perspectives. We welcome you, ma'am. I request the faculty coordinator, Ms. Nirmala, to welcome our guest speaker. Thank you, ma'am. Ms. Susheela is a designated senior advocate practicing in the High Court of Karnataka at Bangalore. She has done her master's in sociology, a postgraduate diploma in industrial relations and personal management from Catholic University, and a postgraduate diploma in alternate dispute resolution from the ICADR. She has over 39 years of professional practice experience and is a trained mediator, trained from the ISDLS, USA, ADR, ODR, United Kingdom, and from the Strauss Institute, Pepperdine University. She is a senior mediator and master trainer associated with Bangalore Mediation Center and recognized by the MCPC of Supreme Court. She has authored several books, including 2 books on mediation in English, which are Mediation, a Reader's Handbook, and Change Through Mediation, and a book in the Kannada language. Her recent books, Hindu Marriage Act and Substantial Question of Law, have received appreciation from students and academicians, as well as lawyers and judges. She is a renowned columnist, and her columns on legal issues regularly appear in leading Kannada newspaper, Vijayavani. She appears regularly on the small screen in discussions related to social and legal issues and in spreading awareness regarding several concepts related to, as well as the advantages of mediation. Her blog on training of trainers in mediation provides inputs to trainers in the field of mediation, and her recent English novel titled I Am Rayon touches many gray areas related to the agony suffered by children of disputing parents. Ms. Susheela was one of the members constituted by the Mediation and Conciliation Project Committee of Supreme Court of India to prepare the draft legislation on mediation. She is a resource person for national and state judicial academies and is also a professor of practice at CMR Law University. It is our pleasure to welcome you back, ma'am, in the expert field of this dais. The dais is yours.
Respected and dear all, greetings to one and all here. Today's topic is techniques related to drafting and pleading. Considering the fact that I am invited here in the capacity of being a professor of practice of CMR University, I have structured this hours program to give you some practical inputs on these aspects, so that it will be helpful for you to write the exam if you have got paper on this topic, number one. Number two, if you are practicing or if you are joining any firm as an intern. From these perspectives, I have structured this program. First and foremost, you should know why drafting is considered as a technique, or why it is considered as a skill, or why it is considered as an art. A technique tells you what to do and why you should do what you should do. What you have to do, you should know, and why you should do what you have to do. That part of it is covered by technique. When we say drafting is a technique, because it tells you as a lawyer what you have to draft and why you have to draft what you have to draft. This is the fundamental understanding of drafting as a technique. Drafting is also known as a skill. What do you mean by skill? Skill tells you where to do what to do, when to do what to do, and how to do what to do. What and why are the integral parts of technique. But where, when and how is skill part. Where you should bring that aspect, when, whether in the beginning or at the end, or after 5 or 6 months, or during the process of the litigation, after 5 years or 3 years, all these aspects must be known to you. So the skill part tells you how to do, where to do, and when to do. How do you acquire skill? Skill is acquired by your experience. You work with several lawyers as an intern, or can also be acquired by expertise. If you read lots of citations, judicial precedents, you will know, oh, this is where there has been a drafting error in drafting. Oh, this drafting is appreciated by Supreme Court in such and such a case law. So by and large, we used to say it comes by experience. Nowadays, we are also adding the expression expertise also. So maybe an youngest lawyer will draft it better than me with 39 years of experience. This also is a fact. So skill is generally acquired by experience, or by study, or by observation. This is skill part. This is one thing that you have to say. So drafting is a technique because you should know what you should draft and why you should draft what you should draft. It's a skill because you should know when you should draft something, where it should come, and how it should be drafted. That's where it is considered as a skill. It's also considered as an art. Why do we consider it as an art? Because there are 3 components in art, any art for that matter. One is the ability. The next one is process. The third one is the product. Ability means what is that is inside you, your capability. It's your intrinsic worth. It's something that's within you. If you don't have anything within you, you can't draft. There should be something within you. That is the ability part. You have to work on that. If you want to be very good at drafting, first is fundamental is ability. You have so much of knowledge, but process, how do you put it? That is the process. How you do what you do is the process part. The third one is the product, outcome. If you have the ability within you and if you adopt the proper process, then the outcome or the product will be very good one. That's where it is called as an art. So, by and large, drafting is a technique, it is a skill, it's also an art. Hope I am clear on this. Why it is important, you know now? No. Why should we know about drafting as lawyers? If you want to put the pleadings of the parties on record of the court, it can only be through drafting. In order to put the pleadings of the parties on record, you need the drafting. What is a pleading? Pleading is considered as a statement in writing. It's a statement in writing filed by the parties to the suit. Let us understand it at a grassroots level. All concepts must always be understood at a fundamental level, then you will never go wrong. What is a pleading? Something put in writing by the parties to the dispute on record of the court. In writing it should be. That is what is pleadings. What is the objective of pleading? The objective of the pleading is to put forth or to demonstrate before the court as to what the party wants to happen and what he does not want to happen, what he agrees to or admits, what he does not want to agree to or disagrees. This is in general about pleading you should know. Pleadings are important because pleadings will help the court. Ultimately it is who has to take a decision? Court has to take a decision. Pleadings, through pleadings, court will know the contentions of the parties before it. Through the pleadings only, the court will know the contentions of both the parties. It is not for the court alone, it is for each other party also. What is the contention of this party? This party should know. What is the contention of this party? This party should know. So that they are not taken by surprise. This is the fundamental objective of drafting, pleading. That's where do not take anyone by surprise. You start giving evidence, but there is no pleading at all. You start telling something, arguing something. Whenever we get RSA, regular second appeals before the court, court will listen to us and then they will say, Susheela ji, we appreciate your argument, but where is the foundation laid? What all you are telling is acceptable, but where is the foundation laid? It's not at all laid. In second appeal, I cannot be putting a foundation. We should have put in the original suit at the first level. So the idea is not to take the other side by surprise or put forth everything. Hide करेंगे, बाद में दिखाएंगे, नहीं हो सकता है. You have to place everything. That's what is pleading is all about. Pleading, what is a pleading? Pleading is something which contains all details in order to see to it that the other party prepares his or her answer to what you have said. You give all inputs. Let them prepare. If I say I am Susheela, if she wants to dispute that she is not Susheela, she is Rama or Uma, let her dispute. She is free to dispute. But I will tell why I am Susheela, I am not Rama or Uma. This is what in essence is about. Drafting is something through which you put the pleadings in a proper frame. Oh, this one? Okay. Through the drafting, you put the pleadings of the parties in a given frame. Now, it is on the basis of the pleadings only you can make a claim. You can make a prayer to the court, decree my suit or dismiss his case, whatever it may be, either for praying a decree in your favor or praying the court that his prayer or her prayer should not be considered, either way. So in order to see to it is this, you should draft the pleadings in such a way that it forms the basis for the claim or rejection of the claim or prayer. This is another thing. In order to understand drafting and pleading in a better way, you should know that by and large, there are two structures that will help you in very good drafting. One is knowledge of substantive law. What is the law? Supposing my father has died, we have 3 daughters, and my mother is there. What does the law say? If my mother dies, what does the law say? This is substantive law. Procedural law. Substantive law and procedural law. Civil procedure code, criminal procedure code. Today I have structured this 1 hour session revolving around civil suits only. Probably you can import this to writ jurisdiction and other jurisdictions. Criminal procedures and other things I am not going to deal with because I structured it only for an hour's session here. So substantive law is something which is fundamental, and then procedural law is also there, because ability, you should know the substantive law and also the procedural law so that you adopt a proper procedure. Today I go before the court and say my father has died, it was my father's property, where 3 daughters give me 1/3 share. Will court give? There has to be a procedure. You have to put the plaint. My sisters should come there and they have to file the return statement. They may agree, they may disagree. So the process is also equally important. In order to place the drafting in the proper manner, have command over procedural law and substantive law also. When I say pleadings, by and large pleadings include plaint and written statement. Whatever you put in writing before the court for the purposes of placing it on record is pleading. It can be plaint or it can be written statement. The two main pleadings are by and large considered as plaint and written statement. So what is a plaint? Plaint is the statement of claim. I want the court to declare that I am the owner of this CMR university. This is my claim. So this is a plaint. The claim is nothing. A statement of claim is what is known as plaint. Plaint is a statement of claim by one person. Written statement. What is the written statement? Statement of defense. Statement of defense by the other person. If I say this, I am the owner of this CMR university, probably the other persons will come and say, Susheela is not the owner of the CMR university, dash and dash are the owners of the CMR university, these buildings, etc., etc. So that is the statement of defense. This is what is called as written statement. There is also something known as replication or rejoinder. This can be pleaded with the leave of the court. You can't simply, I file a case, I am the owner of this property. B comes and says, no, you are not the owner of the property. Supposing I have filed a suit for partition, telling that my father has died, 1/3 share because we have 3 daughters. My sisters will come and say, No. You can't be the owner of the property. Though section 8 is there, you are claiming under section 8. Because all the 3 daughters will be equally entitled after the death of the father, if we are Hindus. My sisters will say, our father has executed a will, registered will, that this house property should go only to 2 sisters, not to Susheela. This is the written statement of defense. Then what do? I file a rejoinder. What is that rejoinder or application? I file with the leave of the court that no, that will is a forged one. I have another will in my favor, that I will file by way of rejoinder. Then they can also file additional written statement. Who? My sisters. They will say the other will that she is claiming is forged, but our will is the genuine one. Now, how many wills are there before the court? 2 wills. One claimed by my sisters, one claimed by me. So, one is plain, where I put forth my claim, that is a pleading, and then they come out with a written statement where they say, I don't have 1/3 share, but it is their own, because my father has executed a registered will in their favor. Then I come with replication where I say, no, that will is a forged one. And I also say I have another will in my hand, wherein my mother's share is executed in my favor. Then they again come out with additional written statement and they say, no, this is not true, that is a forged document. So, plain written statement, rejoinder or replication, and additional written statement if needed. These are the things that can be filed at different stages. In addition to this, you can also file, when a plaint is presented, you can also file something known as, in your written statement, you can also plead about set off or counter claim. Defendant can state how he wants to set it off, number 1. Or he can also make a counter claim. Set off is a good ground of defense for the defendant. Set off is a good ground of defense for the defendant. Whereas counter claim is a weapon against the plaintiff. Please understand the difference. If you want to know more about it, that's why I said, again, ability. Read Order 8. If you are for defendant, you should have complete knowledge of Order 8, Rule 6, Order 8, Rule 6A. 6A refers to counterclaim. Supposing a case for divorce is filed. Wife says this on the ground of cruelty, husband wants a divorce. Wife says no, these grounds are all completely incorrect, not true. She seeks for counterclaim. What is that? I want restitution. I want my husband to take me back. This is a counterclaim by the wife. So, if you want to know, supposing it's a partition suit. Sisters file a partition suit. There are 4 sisters. Only 2 sisters file partition suit against 2 brothers and 2 other sisters also. There are 4 daughters and 2 sons, let us imagine. So 2 sisters have filed a suit for partition. On this side, opposite side, who are there? 2 brothers are there, 2 sisters are there. 2 brothers say, nobody is entitled, it's our father's property, only we, the boys, sons should get, the plaintiff's suit has to be dismissed. But the other 2 daughters are there, no? What they will do is, no, if you are going to decree the suit of the plaintiff, allot our share also. So they will make a counter claim and they will say, if you are going to give a share to the plaintiff's 2, that is 2 daughters, allot our shares also, we will also pay requisite court fee. They will pay the requisite court fee. That's where a lawyer should know while drafting the written statement whether you have any independent right. If you have any independent right, have a counterclaim done and pay court fee. And in your drafting you should incorporate that. So it has to go hand in hand, substantive law and the procedure law. Otherwise you can't do anything. In order to understand the difference between set off and counterclaim, one of the beautiful judgments is that of Saraswati Oil Mills case. You note down that any time in your life if you come across a case where what is set off, what is a counterclaim. In this decision, Halsbury's Laws of England, they have taken reference to this and beautifully they have explained. It is 1967, within bracket 1967, 18 STC, page number 163. Whenever you have some time, pick up that from the library. Just go through that for 10 minutes. You have 5 minutes time. Make use of that. Go to library, pick up this, read for 10 minutes. Or sitting here, waiting for somebody to come and take your class, switch on your mobiles, go to SSC online, read this. You, at least some paragraphs, straight away you can go and read. So Saraswati Oil Mills gives you all cues about how to understand set off and counterclaim. Now, in order to be very good on the drafting side, what we should read, that's also very important. Order 6 CPC, Order 8, Order 2 Rule 2, Section 9, 7 Rule 11. So 7 Rule 11, I am coming from the bottom. 7 Rule 11 says when a plaint can be rejected. So you have to read 7 Rule 11. Tomorrow a client comes to you, you file a case and then go before the court. Whether that case will be rejected, supposing opposite side is Susheela, they are represented by Susheela madam. I'll immediately file an application under Order 7 Rule 11. The plaint has to be rejected because of these things. 11D, ABCD is there. 11D, opposed to some principle of law. I will say this is what it is, it has to be rejected. So first you have to check 7 Rule 11. Section 9, jurisdiction, whether civil court's jurisdiction is barred, whether you have to go, supposing under the PTCL Act, Prevention of Transfer of Certain Lands Act. This is also known as SC/ST Act for scheduled caste and scheduled tribes, that lands owned by them. Can you go to a civil court? There is a special statute. Section 9, jurisdiction. Matter subject, which is a subject matter of land acquisition. There is preliminary notification PN, there is a final notification FN. Can you come before a civil court? The answer is no. Because there is a special act which says dash dash dash, under these circumstances no other court has got jurisdiction. All those things will be there. So you have to see whether there is a specific bar. Section 9 has to be seen, whether there is a bar of jurisdiction, that also you have to see. Order 2 Rule 2, what all you should ask at once. You file a suit for 3 properties and then the suit is decreed or dismissed. Chhod do. After 10 years, the same party comes to me. Madam Muslim, Madam so and so had filed the suit. We did not file for two properties. I want to file for today. That day I did not ask this relief. Possession I did not ask. In one of the cases where I just argued 3-4 days back, we had filed a suit for declaration and injunction. We means the plaintiff had filed. It has come up before the Honorable Court in RSA. Our case is that we are the owners of the property and the other side is interfering, so we want injunction. During the course of the evidence, our client himself admitted that they have encroached upon our land. They are in possession of the land. Immediately what I should have done? I should have immediately got the plaint amended and sought for possession, relief of possession. The suit is filed in 2003. Now we are in which year? 2024. Today if I say I want to do that, all amendments will generally, by and large, whenever you are seeking an amendment, it will relate back to the date of filing of the suit. But If there is a question of limitation, the answer is no. So within 12 years I should have done it. 2003, अब कम हम कहाँ है? 2024 तक आ गए हैं. Not possible. Section 34 of the Specific Relief Act. So you should also know procedural law, substantive law, Specific Relief Act also you should have knowledge. Then you will overcome that. Order 2, Rule 2, Specific Relief Act. Otherwise, some client comes, you file the case immediately in a haste, you will be in a mess, because after so many years they will know it is because that's where somebody has beautifully said, half the lawsuits are either won or lost in the chambers of the lawyer. How beautifully they have said, half the lawsuits are either won or lost in the law chambers of the lawyer. I don't do this exercise, I don't see these things, and I fight. And Order 6 tells you how your pleading should be. Did you understand now? This is what it's all about. Now you see, you must also know about Order 8, Rule 5. Order 8, Rule 5 specifies that every allegation in the plaint either should be specifically admitted or it should be denied. There will be a clever drafting sometimes. Susheela is an advocate and she is wife of Mr. Rajaram Rao. Then you will say, it is true that Susheela is an advocate, but it is not true to say that she is wife of Rajaram Rao, but she is wife of Mr. R. Chandrasekhar. This is how you have to cut it. Some people will bring everything in one paragraph, and some drafts you will come across. It is false to state that all that they have stated in plaint para 4, they will reply. They will put it as it is. It is false to state that. It will be a mixture of dash and dash are my children. Are you going to deny that also? Not possible. Deny that portion which has to be denied. Admit that portion which has to be admitted. If you want to add anything, clarify it. Clarify it then and there. First few months of marriage we were happy. Were you happy? Say yes. If you are not happy, say no. That means after that, whether you are happy or unhappy, that also you mention. So these are all the things that you have to see. Order 8 Rule 5 says either admit it or deny it specifically, or say that you do not admit, or plaintiff is put to strict proof, defendant is put to strict proof, whatever it may be you can say. You should know before drafting, you should have the ability. The ability is the content within. What is that? Facts. Collect all the facts. Client counseling is very important. Spend quality time with the client. Understand take all the inputs. What is the strength of the other side? See what other defense he may bring and place tomorrow. What is your preparation for that? All these things you must. I will tell you a funny incident. My friend used to tell about this. One of my good friends. There was a client, old client, who used to come to lawyer's office. That lawyer's office with regard to so many, land cases and other things. One day he brought a notice and handed it over to one junior advocate of that firm. So that advocate saw this. Oh, kya hai? He saw that. Oh, see what it is. Okay, he read that. Your wife has filed a case, section 125 of CRPC for maintenance. That's it. That's a petition copy he has received. Who is it? Your wife. My wife. She has died. When? Long back. When? More than 25 years. Is it? Who is Kamala? I don't know. Okay. Drafting prepared dash and dash is not the wife. No way connected. Written statement prepared. Everything is over. and then case went on for after written statement of objections, or what we say is, we do not say it written statement, objections we say when it's a petition under section 125 CRPC. By and large it's a written statement only, differs. So and so is not related, she is not my wife, why should I give maintenance is the whole gist of it. What I want to happen, I want the case to be dismissed because I am not supposed to pay at all because she is not my wife. My wife has died here. Okay. So many days happened and then the case went on for evidence. The petitioner's evidence was also over. Then the cross-examination was also done. Then the respondent's evidence has to be done. Respondent comes and stands in front of the court and then he gives his evidence, and then the other side lawyer. Who is that lady? She is my wife. What's her name? Kamala. Cross-examination closed. Where do you stand? These people take him inside and ask him, you said she is your wife? Yes. You said, but on that day you told that she is not your wife and your wife has died. The day on which she left me and our family, on that day itself she was dead for all of us. That's why I said like that. The matter got compromised, that's a different issue. See, how people tell different things is also very important. That's where client counseling. Those of you who are trained in mediation advocacy and in mediation, you will know how to get the exact information. Others may not know. So gather information, client counseling is very important. That's where you will know. And that RSA I told you, where there is section 34 is now coming in between and I have to see how do I overcome. I have to think a lot. The case is now further adjourned. There, had I been there, I would have asked him, please tell me the truth. Are you in possession or are you not? If he says, I am not in possession, madam, they have encroached, but I don't want to tell. I would have told him, look, if you say that you are in possession and tomorrow you are unable to prove that and they are in possession, how do you dispossess them? That will be too much difficult for you. So the ideal situation for you is to fairly admit before the court, I am not in possession, they have trespassed, they have encroached. Kindly grant the relief of possession along with declaration also, because the title deeds are in your favor. This is how you have to go, isn't it? That's where client counseling becomes important. And substantive law, procedure law, statutes relevant, and judicial wisdom. Why substantive law? A suit for partition filed by a Mohammedan son during the lifetime of Mohammedan father. Is it maintainable? Not possible, isn't it? So you should know about the substantive law also. A son comes, a Muslim man comes to you and asks you to file a suit for partition. During the lifetime of father. After the lifetime of father, that's different. During the lifetime of father, you should say, no sir, there is no law that helps you in this regard. Hindu's law is different, personal laws are different. That's where you should have immediately ask the party to which community he belongs to. Nowadays we are all telling that we should not talk about caste, this, that and all. But at times, to know the personal law and the effect of the personal law, you should also find out this. Matrimonial cases, inter-community marriages, you should know whether it has got an effect on the succession of the party who is coming. Your mother is married to a Christian. You are entitled for partition in your father's property, but your children are not entitled. So these things you should be knowing, isn't it? So by and large, you have to have substantive law, procedure law, the relevant statutes, and all judicial precedents. Latest law, to-date law you should have in your hand. Otherwise the law is changed. What do you do? Now, 2005 amendment, equal right to women in property. Now you can't say, oh, we being only two sons, we are entitled for the entire share. Ladies, girls are married on dash and dash. Earlier the law was, what is the date of death of your father was important. Before that, what is the date of your marriage was important. Now these things have become redundant after that Vinita Sharma's case. So you should have in your tips the substantive law also, and also the judicial precedents where it has been clarified as to how we should read. Adverse possession. Earlier, we could have filed a suit for declaration on the basis of adverse possession. In between, there was a judgment and it said it can only be a defense, it cannot be, you cannot claim it on the basis of adverse possession. Now the law is changed, you can also claim it on the basis of adverse possession. So what is the recent law? You should know. The change in law must also be known to you. More than anything, you should know whether the suit will be barred by limitation or not. First thing you should know, it is barred by limitation or not. Now, one thing why you should do this is, while doing the client counseling itself, it is always better to talk about futility or frailty of the case. It's useful. You have got very good grounds, file the case. You don't have a ground. You have an arguable point. Maybe in the initial stages of the profession, you will lose many clients. Hey, she threatened me, I don't have a case, I will file it through him. They may leave you, but always give proper advice, because you will not be stressed up. For having given false assurance, you will not be stressed up tomorrow, and your drafting will not be objected to by anybody. That's where your professional competence also comes into role. Now there are fundamental rules regarding drafting. The first thing is facts, not law. You should know the law, but you need not plead about anything. Dash and dash, section dash and dash says dash citation is like that, that's overruled, this has come here, here they have followed that. No need. You have to mention facts. Supposing I say the property belonged to Mr. Satish Chandra and I am the legal heir. Satish Chandra has no wife or children, but I am the legal heir. How? I am a class 2 heir. Satish Chandra is my uncle, my father's brother. So I am entitled. So you have to mention the facts and how you are entitled to what you are entitled to. That's where the skill part and the technique part comes into picture. Suppose it is right of way. If this door is closed, I have only one right. All of us will have to pass through this only. These people could have passed if there was a way. So you have to, in case of easement also, you have to mention how you are entitled to what you are entitled to. That's where they say in good drafting, it is not just about your entitlement, but how you are entitled to must also be part of drafting, is what they say. For example, negligence, medical negligence cases. Doctor was negligent. If you simply say like that, not possible. So there an element has to come as to how you say that doctor was negligent, medical negligence, or accident cases. Rash and negligent driving, at least one single sentence will have to be there. Now you see, when we say facts and not law, one area where you have to be very cautious is about limitation. Limitation is by and large now considered to be and accepted to be a mixed question of law and fact. If you have to take any pleading with regard to limitation or overcome the hurdle of limitation, please see to it that in the drafting there is a special statement, a specific statement about this law, because it's a mixed question of law and fact. So, plea on mixed question of law and fact has to be specifically pleaded, is the law laid down by Supreme Court. AR 80 Supreme Court is very relevant, 1818. AR 80 Supreme Court 1818. Mixed question of law and fact. If those of you who are interested, if you want to read, maybe in examination these questions may come. 2 or 3, if you read head note, probably it will be enough. AR 80 Supreme Court 1880, Ram Prasad versus State of MP. That case law will be helpful. So first one is facts not law. The second one is material facts. What is material fact is not defined in the procedural code. It's not defined. That's the problem. Order 6 rule 2. I told you have to read order 6, order 8 and order 2 also I told you. Order 6 rule 2 refers to material facts. The first one says facts not law. But facts sab kuch dalun kya? Not possible. It should be material fact and material fact only. The bundle of facts which would constitute cause of action is what is known as material fact. The facts which will give rise to your entitlement or his disentitlement, that will be a material fact. The material fact is a fact on which a party before the court relies to substantiate his claim or defense. I claim wife of dash. She also claims to be wife of dash. Another lady comes and says, I am also wife of dash. 3 persons. What is material fact to say that only I am wife of dash? What is the material fact she has to say that Susheela is not wife of dash, but I am wife of Mr. So and so? What is the claim that she has got, material fact that she has got to say that these two are not wife of dash, but I am the legally dead wife of dash? These are the material facts. Material facts is a fact on which a party relies to substantiate his claim or defense. This is what you have to understand. If material fact is admitted by the other side, you need not have to prove it. A material fact is one which may have to be proved by the party before the court through evidence if it is not admitted by the other side. Did you understand? So what is a material fact? If you place anything, clients will come to you, file this case. Are you ready to prove this fact? We will bring evidence afterwards. Not possible. Ask them, what evidence have you got? Recently, one very big property in Bangalore, very posh area, they said some Nawab had given to their grandfather, great-grandfather, some areas, 10 acres of land, let us think for a while, in a very posh locality. You are the 6th generation. Through 2 daughters, in between there are 2 daughters, 2 sons and all. How do you trace your title to that Nawab? If I say I am descendant of Lord Rama, how do I trace my title? Let us not go till Rama, at least 5 generations. How do we trace it? That's very important, isn't it? So a material fact is one on which, so you have to tell your client before drafting, this is going to be a material fact. You may have to prove it. What do you have? That has to come in preparation, counseling. So much goes before drafting. It's not just a child's play. That's where, in fact, in India nowadays professionalism is increasing, and we are charging very well. If a pleading is placed before us, they come to us to settle the draft. They engage the services of senior counsels to settle the draft. Senior counsels, we charge heavily, maybe 1 or 2 words, 1 or 2 sentences, 1 or 2 paragraphs, we may change. But so much of the hard work goes in understanding whether the drafting is correct, rightly put or not. Now, the effect of a document is a material fact. There is a document, what is the effect of it? That becomes a material fact. Supposing it's a case of adverse possession. Who is the true owner? How the possession became adverse? When did you enter into possession? Has 12 years been over? Then only your right fructifies, isn't it? So all these things you have to. If it's a suit for injunction, first thing is, are you in possession? I am in possession. Whether there is interference. These are the primary things. You have to read the substantive law and the precedents and then file. If you are not in possession, you can't file a suit for injunction. Bare injunction you can't file. This is what is the material fact. Next is facts, not evidence. You need not put forth all the evidence you have in your plaint or in your written statement. You can make a statement about the material facts. You can allege that what is claimed to be a material fact is incorrect and not admitted, but keep your evidence outside. You can put it during the course of your evidence. So evidence need not be pleaded is what is important, but evidence has to follow the pleadings. Evidence need not be pleaded. You need not have to put it in writing. But whatever you have pleaded, if the other side doesn't admit, you will have to prove. So I would suggest while drafting, what you cannot prove, do not put it in pleading at all, because you will be caught hold of by the other side. Next rule is concise form of pleading. Pleading should be very concise and it should be neat. And when I said you need not have to give all the particulars, there is one exception. If you are pleading fraud, undue, see, generally we say the document is concocted, it is a reflection of fraud, undue influence, coercion, all those things, misrepresentation, we say. No. What is undue? Read Contract Act. Read the definition of all these things. Read all precedents where they have said what misrepresentation is, what amounts to negligence, what amounts to mistake, what amounts to fraud, what does not amount to fraud, what amounts to undue influence, coercion, collusion. These are all different terminologies, different expressions. So you have to read and then say what it is and why it is what it is. Again, technique. Technique is what you have to plead and why you have to plead what you have to plead. That's where drafting is considered as a technique. Breach of trust. Why it is breach of trust? My property I had given to my mother-in-law. The Sridhan property, the jewelry is given to me by at the time of my marriage. That was part of it. It has now been liquidated, and then all other sons of the family have used. Now today I am a widow. I want that property. There is a breach of trust. Whatever it may be, how you weave it is different. But if you are taking a plea of breach of trust, please give some particulars of it. All evidence need not be placed, but there has to be pleading with regard to particulars. When I said only facts and material facts, generally we avoid particulars, because particulars, if they form part of evidence, we can avoid. But particulars with regard to these things cannot be avoided. This is where the exception is. Desertion. When your husband deserted you, cruelty, some particulars of cruelty have to be given. Easement, legal necessity, these are all the areas. Now, there can be alternatives and inconsistent pleas also. Supposing I have filed a suit for declaration and injunction, I can also say, in the event the court comes to a conclusion that plaintiff is not in possession, then the plaintiff prays that the court may be pleased to grant relief of possession by molding the relief. It's alternative. Even that prayer was not done in that case that I told you in the beginning. I gave you an example now, where section 34 was coming in my way. I am in possession. Assuming for a while after evidence the court comes to a conclusion that I am not in possession, then grant me relief of possession. Alternative pleas can also be sought for. But mutually destructive pleas you can't ask. That's where you must be very careful. Whether it falls under the category of alternate, inconsistent is different, but whether it is mutually destructive is also must be. Now, how do we structure the drafting? Heading and title, you must be very careful. Recently, the matter got settled. I was arguing a CRP where, a civil division petition, where the contention of the plaintiff who had filed a suit for declaration that he is adopted son of some Iyengar, let us say some Raja Iyengar, adopted son of Raja Iyengar. Okay, that's his case. And there is one deed, one paper, unregistered paper, on which he wants to rely upon as to claim that he is son. Now, what is the title? Mr. Somshekhar, son of Ramayya. If he claims to be son of Iyengar, title itself should have been like that, isn't it? That's where. So, a lady files a suit in respect of all the credit standing to the credit, all the assets standing to the credit of her deceased husband. Suma is the plaintiff. Rani is the defendant. Another person, Rani's son, is another defendant. Rani has also made her objections, filed her objections before the LIC authorities and to all the PF authorities, KGAD authorities, etc. that so and so was my husband. So me and my son should get. This Suma has also filed her claim petition that she is the wife and everything should come to her only. In the authorities said you go before civil court, decide who is the wife, who is not the wife. Suma, while filing the case, should not have mentioned Rani also wife of Dash only, her husband only. At least what she should have done, claiming to be wife of, she should have written. And her son, Babu claiming to be the son of, they should have written. But what they have written? Son of. When the matter comes before the High Court and you say, Madam, please see the cause title, what do we say? They have paid us so much, yes, I have pocketed the money, but the cause title is glaring at you. That's where in the heading also, in the title also, you should be very careful. The property is purchased out of the hard efforts of, joint efforts of all of us, including the plaintiff. Plaintiff struggled so hard to purchase this property, everything you mentioned. What is the age of plaintiff? 24 years. When was this property purchased? 1952. Where is nexus? So be careful about hitting and title. And body portion, what you have to mention? Mandatory clauses. Some mandatory, this, if it is a writ petition, there should be, this writ petition does not challenge the constitutional validity of any statute or any circular, etc., etc. There will be some statutory clauses. The suit is filed within limitation. All those things will have to be statutory. If it is a matrimonial case, there are no other cases pending between the spouses with regard to the subject matter in issue, or excepting dash dash and dash mentioned in para 5. Something of that kind, mandatory clauses will have to be. What is the relief? Always add a para that plaintiff may be reserved with the liberty or kindly grant any other relief by molding the relief to which he said. So order 7, the molding of the relief court can take. If this relief cannot be given to the party, what other relief can be given? So there has to be a scope for molding the relief. That also you must think. What is considered as a good drafting? Even if everything you have stated is accepted or proved, would your client get what he wants to get? That's what ultimately, okay, you have filed this, court is acceptable, everybody is accepting what you have stated. Will he be entitled to? That's where the substantive law comes. Yes sir, you are son of Sheikh Muhammad, correct, everything is correct, everything is accepted, but Sheikh Muhammad is alive now. When he is alive, how do you get share? Not possible. So again going back to substantive law. That's where this everything is connected with why we request you to be very attentive in every class. One class you get some input. That has connection with another topic. Evidence Act, somebody comes here and gives a lecture, goes. I come here and give a lecture on drafting, go away. But if you have what is section 68, what does section 69 say, what does 71 say, and then relate to what I have said now, then you can bring. Otherwise you can't. That's where I would request that please give your 100% attention to your sessions. Because these are all practical aspects and theory aspects. Both there has to be a perfect synergy. Some of the blatant errors I would like to tell. See, in one case, another 5 minutes time I have. No, I have this. The defendant said, plaintiff had filed a suit for injunction. It was a mining land, huge mining land, very rich client of ours. The other side, they said, plaintiff is a rank trespasser. That was their first sentence. Didn't argue anything. I just showed that. Sir, this is what they have said. Plaintiff is a rank trespasser. That means he admits that I am in possession. Even a trespasser has to be evicted according to due process of law is the law, isn't it? So I am entitled for injunction. Granted. High Court also, MFA also, injunction confirmed. If I am in possession, the course available for him is to see to it that I am evicted according to due process of law. Today I have come here. After the class I don't go. I resist. I want to be here only. Can you push me out? I continue to be here for n number of years. If you want to push me out, you have to take recourse to law. Push me out in accordance with law. So even a trespasser has to be evicted in accordance with law. So had he not used the word rank trespasser, plaintiff is trying to trespass is different. He is a rank trespasser is different. That's where the blatant error in drafting. Another case, a beautiful case I remember, where we had filed a suit for partition. The other daughter was, well, let us imagine that there is Kempamma, who is one daughter who was filed against Sondamma, another daughter. So, Sondamma's case was that Kempamma is not at all my sister. That was what she was. I am the only daughter, so I am entitled for all the properties. We had no documents to prove that Kempamma is daughter of dash and dash, because in those days, before the girls used to come to maturity, they used to get married. Even less than 12-year-old, they used to get married. So she went to some other village where her, so all the records, voter list, ration card, everything reflected the name of Kempamma's husband, not of father. This Sondamma claimed to be daughter of Chaudaya on the and she also said there is a registered will. This is her case. Now you see, Sondamma's case is I am the only daughter. Repeatedly they said, when Kempamma filed the suit, in Kempamma's plate, Kempamma had said, my sister is denying that I am daughter, that they need not have put, but they have put. My sister is denying that I am the daughter of so and so. Kempamma and Sondamma look alike, like twins, she had said. What is the written statement from this side? It is not true to state that Kempamma and Sondamma look alike. Kempamma is very dark, Sondamma is very fair. It was exactly like that. We had a movie in those days, Kappu Bilappu, I don't know how many of you know. Twins, one is dark, one is... Kempamma and Sondamma were really, I still remember, I have changed the names here, they were really like identical twins. She is darkened. Why should he have committed this in the written statement? While recording the evidence, there is also something which says that you can record the demeanor of the parties. Can you see her eye to eye and tell whether she is your sister or not? Means the other side said that, Sondamma said, I don't want to see. She was not even ready to see, because it was as though they were mirror reflections of each other. She is dark version. This is one part. Second part is, I am the only daughter and my father has executed a register. If you are the only daughter, why should your father execute a registered will? After his death, it will go to you automatically. These are all the blatant errors. You need not have to. Yes. So this is mutually destructive plea. I said you can take an inconsistent plea. Supportive inconsistent, but mutually destructive plea. She is not my sister. I am the only daughter. And there is a will. You could have said she is my sister. But there is a will. It would have been a better case. That's where you are drafting. And there was another case where they said, even after lodging 3 police complaints, he did not vacate the house. Grant me an order of injunction. Not possible, because you are admitting that even after you have given complaints thrice, they have not vacated, means that person is in possession. So he has to be evicted in accordance with law. This is another. There is one more thing that I would like to say is moderation in language. Moderation in language is always considered as the hallmark of pleadings. Moga's laws of pleadings you have to read. Then he says it's hallmark of pleadings, moderation in language. Order 6 Rule 16 says, where it is vexatious, scandalous, the court can strike off the pleadings. In many cases, courts will expunge. They will say, you remove that. This paragraph, you have to remove it. Court will order us. In one case, there is what is it? A Sumant Prasad case, year 1946. If you put it, you will get it. They said plaintiff's son is a avara, vagabond. Court said you can't be making such allegations. Nowadays, in matrimonial cases, they send us the techies, highly qualified people whose qualifications run into 2-3 lines. They send us. He is narcissist. He is schizophrenic. He is bipolar. Alright? Are you a psychiatrist? And that person took serious objection. Madam, I am a doctor. If she calls me a bipolar, from tomorrow nobody will come to me. I am a registered doctor. How can she say I am bipolar? Schizophrenic. Even if you are schizophrenic also, it is very difficult to get a certificate from the doctor, because it is a very big process. You can't be making such. In one case they had said tale kettavulu, and in another case they had said he claimed that he is PhD. It is true that he is PhD, but bracket they had written pure head damage. Such things you can't be making. We had to ask the client to remove these things. This is vexatious, scandalous, and it should be very dignified. Do not tell your client that they should work within the boundaries. It's not about the person, it is about the problem. Separate the person from the problem. Let them handle the problem. So again, going back to what I said, this is what ultimately it's all about. Hope I am clear. Thank you all.